and welcome to a newsflash episode of Unpacking the Case, the podcast by David Jones Bold, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape. Hello, Richard.
Hello, Lizzie. Cold day.
It's a cold February day. It is indeed. And we're here to talk about...
And it's the day before my birthday, don't forget.
Of course, yes. As you told me just before we hit record, it is your 40th birthday again tomorrow. So you've got that to look forward to. We are returning to a topic from our webinar on the 12th of February, which is around responding to CPSE enquiries. We had an inordinate amount of questions. So we've got some of those questions that we weren't able to answer today for the podcast audience. So there's a lot to get through. Should we get stuck into the first question?
Okay. Mm-hmm.
So the first question is, are you obliged to highlight answers which are unusual in bold, particularly for an auction sale?
It's not particularly about the CPSE enquiries, but it's, I suspect, referring to the case that we did a few years back in 2022. We mentioned in a podcast, SBS Groundworks and Mahil. A strange sort of High Court decision, I think almost certainly wrong, quite frankly, where the property was subject to overage, which the successful bidder who exchanged at the auction could have easily found out, because they given every opportunity to look at the pack where they'd have seen that there was an overage deed, and the official copies at the land registry, referred to deeds of covenant and restrictions to protect the overage against third parties. But they said that overage was a defect in title, did the judge, and your duty is bound to tell people about defects in title. And it's not enough to give them every opportunity to try and find out. I can't believe it's right, but I think that's what you have to do in auctions, just in case. You've got to assume it is right. So you have to sort of highlight the fact that any defects, and I think I've answered the question. Mm-hmm.
Next question. Would a response such as, please do your own searches or survey suffice?
Yeah, I mean, as long as you're not sort of committing yourself, but it's a matter of whether the other side sort of accepts that fact. If they're questions which are nothing really to do with law, like sort of physical condition of the building and the likes, then I don't think they should be a part of inquiries, quite honestly. It should be down to caveat emptor, but if they're standard CPSEs or additional inquiries which are legitimate, I wouldn't accept that myself. But yeah, depends on the nature of the inquiry. You can always say no, but it's just a question of whether the recipient accepts it.
What about seller is not aware, but seller has not made any inquiries in this regard?
I mentioned in the course that not aware might be, or not known might be, taken as a representation. You've taken all reasonable steps to find out. A reasonable person of your situation, a reasonable lawyer, a reasonable surveyor, a reasonable member of the public. I prefer just to drop not aware yourself, not mention that.
Where they say not to our knowledge but rely on your own survey in CPSE, which takes precedence, the representation or the limitation?
Well, you can't. Well, it's any limitation of liability for misrepresentation has got to be reasonable under Section 3 of the Misrepresentation Act of 1967. And the case I mentioned, the first tower in CDS Superstores, the Court of Appeal said it's you're hard pressed to find situations where it would be reasonable. I just again dropped the not aware bit, quite honestly. So it's not a limitation of liability to limit what your retainer rely on your inspection or survey.
Thank you. Yeah. Another attendee asked, I understood that the CPSEs implied that the person responding had made reasonable inquiries. Can we get around this by simply saying, but the seller has not made specific investigations in respect of this?
Yeah, I mean, I think you probably could. It's what we just said previously, that, it's the implication is you've sort of, if you say not aware, you've made reasonable inquiries. But you can limit yourself. Our client's not an expert. No investigations have been made. It's the clients filling in the CPSEs. It's not that, unless you're in-house. It's not the solicitor or the surveyors.
Does a seller have to notify of any asbestos in any sale of any property, or would this be in the CPSE?
It is in the CPSE Enquiries. There's a whole list of things which, have this been used and the likes. And so it would reference, you don't have to answer them. I say the exception might just be the one we started off with in an auction because it's not really a defect in title, really. But if a property of a certain age, I'd want to see an asbestos risk assessment and any management plan, quite honestly, if I was a purchaser. It's certainly pre-2001 build or conversion. I wouldn't accept it.
Next set of questions are all around the fire risk safety risk assessment. So what if the property is vacant and secured whilst being sold? Surely there is no need for a fire risk assessment if there is appropriate detection and security.
Well, I mean, I might just say that that's the fire risk assessment. Quite honestly, you've got appropriate detection and security, but they should have an empty property pending sale or pending being rented out. Let's assume the freeholder of the property, is the person who's about to sell or whatever, who is the duty holder. They're in control of the premises. They should have an asbestos risk assessment, and it's just a matter of, a fire safety risk assessment, and it's just a matter of what you do for that fire risk assessment.
I think the next question is a similar one again. If the property is vacant and no occupation, does it still need a fire risk assessment?
Yeah, I mean, somebody still has, control of that premises. It could affect your insurance still.
Mm-hmm.
You could, in theory, be prosecuted, but I think the real risk for empty properties is what it does to your insurance. If you have another fire risk assessment, your insurance is going to be higher anyway if it's long-term empty, and it might just be litigated.
Okie dokie. Next question. If your client instructs you to proceed without a fire safety risk assessment or asbestos survey, as a potential criminal offence, does a proceeds of crime report need to be filed?
I think I mentioned this in the course. I mean, I've heard that argument years ago, and I sort of stood a bit on the fence in the course, but I don't think it does. People were talking about that in the past. To be the proceeds of crime, it's got to be criminal property. In criminal property, it's got to be property acquired through the benefit of the person's criminal conduct. And they know or should know the fact it's criminal property. The fact that you have another risk assessment in relation to the premises doesn't make it criminal premises. So I don't agree with that myself, but not everybody might say the same thing. Or be committing criminal offences all the time if that was the case. Yeah.
Lots of reports would be filed.
Mm-hmm.
Is a tenant under an obligation to provide an asbestos survey if they are in occupation?
The asbestos risk assessments, unlike fire safety, they latch onto who's responsible for repair and maintenance. So, if the tenant's responsible for repair and maintenance, which in the commercial property they probably are, they're the ones who should have an asbestos risk assessment. And if the landlord's responsible for repair and maintenance for the exterior and the common parts and collects for a service charge, they should. So it's the person who's responsible for repairs under the lease.
What about new build properties? Why do they require an asbestos assessment, and which common parts in a domestic building apply?
Yeah, Control of Asbestos Regs 2012 don't distinguish between new builds and existing properties. But the Construction Design and Management Regs should have a health and safety file, which basically says there's no asbestos, amongst other things. I think the residential inquiry, so it's the LPE1, the residential, the management inquiries for residential common parts, they've probably got it right that blue asbestos, I think, was banned in 1987 and brown in 91. And they're a totally different chemical substance than white, which is, again, the surveyors might contradict me, but the same as in talcum powder. And that was the year 2000. So the residential LPE1s say that if it was built or converted prior to 2000 or from 2000 after 2001, I think they say, then you shouldn't bother with them, but otherwise you'd need an asbestos assessment, and I think that's probably right. As to the second part of the question about domestic premises, common parts of flats and the likes being non-domestic, it's not actually in the regulations, but there's been cases in the past. There was a case called Westminster City Council. It was about health and safety regulations involving Westminster City Council back in the 1980s, select management, I think it was, which said that non-domestic premises include the common parts of dwellings. And the guidance from the health and safety executive says that non-domestic premises include the common parts of dwellings, and that's where it comes from. Well, the common parts are obviously things like foyers, vestibules, corridors, and so on. But the suggestion that it could be further than that, sort of, anything that's not part of the actual flat itself. You should have asbestos risk assessments in relation to the sort of piping and the boiler system and this kind of stuff. That's where it's from.
Thank you. Next question. They're quoting from the notes here. Likewise, they must pass on to such persons a copy of a leaseholder deed of certificate within a week. And their question is, does this mean the landlord has to provide the residence management company or right to manage copies of the completed deeds of certificates that it's received back from the leaseholders?
The answer is, this is about the Building Safety Act, and we've moved on from asbestos and fire safety. Yeah, I mean, it was changed in 2023. It wasn't in the original provisions, but the regulations say that you have to provide within a week, not just to other landlords in the block, but you have to provide the deed of certificate to right to manage companies, residence management companies, and named managers of people who haven't got an interest in the property, a property right in the property, but they are responsible for repairs and management and so on. But yeah, otherwise you might just lose the ability to charge qualifying leasehold to be a service charge for works. Mm-hmm.
Another one on the Building Safety Act. Where do you measure the 11 metres from? Ground level or basement light well level or pavement level?
Well, it's visible with both the regulations and the non-statutory guidance. It's the lowest part of the ground level, but they don't deal with. I've seen situations where you've got almost like a trench between, the lower floor, if you like, and then it rises upwards, and it's not really dealt with. Somebody did contact me on LinkedIn about that, and what did I think about it? And they said they were going to litigate, but I've not seen anything since. And that was about a year ago. I'll have to contact him. But yeah, it's the lowest point of the ground floor.
And generally, a listed building was considered exempt, but do you need formal exemption?
Listed buildings, contrary to popular belief, are not exempt. I mean, it's not the best drafted legislation. This is from energy performance certificates and the likes. You don't have to comply with any recommendations if it would unacceptably alter its character or appearance as a listed building. Well, that doesn't mean to say it's automatically exempt. If you've got sort of sash windows or something, old sash windows, and the suggestion was you can make it a higher rating by replacing them with UPVC tertiary glazing, that would unacceptably alter, I would imagine, character. If it says change all the light bulbs, that's not going to unacceptably alter the character or appearance. So it's a strange one. They should almost have an assessment to find out whether the work should be done or could be done in the first place, but they're not exempt, no, contrary to popular belief.
How can you find out if a building is registered and has a safety case?
Case report. I presume that we're back to the Building Safety Act here.
Yeah.
This is for higher risk buildings in England that need to be registered and have, the safety case report has to be provided to the regulator, the building safety regulator, within 28 days of a request, not to register and not to provide the report of both criminal offences. And so you should really have a safety case report up and running. You can look at the Health and Safety Executive website and you can find out from that whether it's been registered or not. I mean, most properties have not had the regulator call in the safety case report already, but there should be one in place because you do get asked for it. There's no way you're going to provide it in 28 days if you haven't even started on it. It's a hefty piece of documentation.
Is it a risk to answer not applicable to the question, is this a high risk building, when you're confident it's not a high risk building, but no assessment has been carried out by a surveyor to confirm that?
If you're absolutely certain it's not 18 metres or 7 or more stories in height, then it's not a high risk building. It's in the margins that the problem is. If you're dealing with a bungalow, I'll be pretty happy to say that this is not applicable. But it's in the margins because of some of the cases which are still up in the air, and the government saying they're going to change the higher risk building regulations. I'd be careful with the sort of, as in some of the cases, a 6-story with a roof terrace, that kind of thing. But if it's absolutely certain it's not anything close to 7 stories or 18 meters in height, I think you can safely say that.
And how long are CPSEs valid for?
It doesn't say in the inquiries themselves. It's how long you want to rely on them for, really. They should be valid until the moment of exchanging of contracts. If you do exchange contracts, or if you go straight to completion, is when they should be valid for. And if circumstances change in the meantime, it does stay in the explanatory part at the beginning of the CPSEs that if circumstances change, you're going to notify the changes to the recipient immediately. There's cases going back many years, but Whitton O'Flanagan, which I think was in the 1930s, that said basically if circumstances change, you're duty bound to notify the changes without further request. Now, having said that, I think I would, if there's been a big gap between the CPSEs being filled in and you've been about to exchange contracts, I'd probably, as a purchaser, want an update anyway. But it's the sellers, if the circumstances change, the seller's going to be liable to misrepresentation if they don't notify the changes. There's no set time.
Okie dokie. Thank you very much, Richard. I think that's as many questions as we can cover in one podcast, but I'm sure there are a few that we haven't managed to answer, but that has been a fair amount, I think.
Yep, probably the most we've ever had.
Thank you very much.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.